know.
Do you know who took Summer home when you first come home?
I'm not doing all that. I'm not doing all that. I can't do this.
So listen, they're trying to help. They're trying to help.
It's not out with me.
I know, but they might.
There's nothing more to remember. I gotta go home.
Listen carefully. What I'm about to read you is a careful, unflinching look at a single, explosive thread in one of the most watched missing child cases of the last decade. This script does not rehash every detail you already know. Instead, it focuses tightly on one claim that, if true, radically reframes everything. The allegation that a parent privately admitted authorities were uncovering crimes far beyond mere neglect, and the ripple effects that admission could have across law, investigation, and a small town's sense of safety. I will make something very clear up front. Much of what follows is built from reported allegations, whispers, and community accounts, not courtroom findings. Where I describe claims, I will label them as such. I urge you to approach what you hear with the same care. If you want to stay close to this developing story, subscribe to the channel now and turn on the notification bell so you don't miss any official updates, investigations, or verified documents as they emerge. 4 months, and then years. The disappearance of a little girl made people look differently at a stretch of rural road, at a porch light, at a missing pair of shoes. For the family, for neighbors, for the search teams and the investigators, it was a wound that refused to scab. But sometime after the initial surge of searches and the national attention faded, a different kind of story began to circulate in small circles. Private conversations, off-the-record remarks, statements passed from neighbor to neighbor. One of those remarks, chilling in its implications, is the one we will examine tonight. It is the allegation that a mother made a private admission to someone close to her, that Child Protective Services had been digging into allegations far more serious than anyone had publicly assumed, crimes committed against children inside the home. That is the allegation. It has not been proven in court. It is not a verified confession accepted by investigators in public record. But because of the nature of the claim, because of the stakes involved, we cannot treat it as mere gossip either. We have to understand what it would mean if it were true, how it interfaces with law, how it reframes the timeline of events, and why the community's response matters as much as any single piece of evidence. Start with the most basic truth. When a child vanishes, every small detail becomes a potential key. Investigative work is a mosaic of tiny, easily overlooked things. A phone ping on a particular tower, a neighbor's recollection of an unusual vehicle, a social worker's note about parental neglect. In the Summer Wells story, many people focused on the visible pieces: posters, search parties, interviews. But what some neighborhood voices started to whisper about were the invisible threads. Conversations between local agencies, a CPS investigation whose records were not public, and an alleged private admission by a parent that the removal of other children from the home was not just routine but tied to serious crimes. The allegation alone raises urgent, uncomfortable questions. If CPS had been investigating more than neglect, if investigators had suspected abuse or exploitation, then the context in which the family lived, the decisions CPS and law enforcement made, and the timing of every intervention could look very different. It would also, crucially, change how we interpret certain public statements and private behaviors. That's why the allegation, though unconfirmed, demands scrutiny. Let us be explicit about the language. An alleged confession does not equal a conviction, nor does it equal a verified statement made to law enforcement. The claim here is of a private remark, a person telling another person that CPS was investigating serious crimes involving children in the home. That kind of remark can be devastatingly consequential for how people imagine culpability and motive, but it also lives in a perilous legal and ethical gray zone. Memories can distort. Motives for spreading a story can be personal, political, or protective. And hearsay, by itself, rarely carries the weight needed for charges. Still, rumors are not born out of nothing. They are often seeded by fracturing trust, by observed inconsistencies, by procedural scraps that the public can sense even when they cannot read them. So the real work for anyone seeking truth is to move from the sphere of rumor into documentation, to identify who said what, when, to whom, and under what circumstances. Investigators focus on corroboration. prosecutors demand evidence. Communities crave answers. Now, explore the possible legal dynamics that make this allegation as dangerous as it is compelling. Because in most jurisdictions, including many states in the U.S., criminal liability for abuse or exploitation of children is not easily erased by administrative acts like signing away parental rights. The idea that a piece of paper could erase criminal responsibility is a misunderstanding of law. Removing parental rights might alter custody and civil liability, but it does not make criminal acts disappear or bar prosecutors from pursuing charges. In practical terms, this means that if there were allegations of criminal conduct in the home, simply transferring custody, placating CPS, or signing documents would not necessarily immunize anyone from later prosecution. In fact, it could sharpen scrutiny because prosecutors would see administrative maneuvers as potential attempts to avoid accountability. That creates a legal window, sometimes years long, within which investigators and prosecutors can present charges if evidence supports it. The practical consequence, alleged confessions, even private ones, can be the seed of an investigation that blooms years later into an indictment. That is one reason this rumor, when treated seriously, should alarm everyone. Consider, too, the role of timing. The private confession allegations surfaced long after the initial search frenzy had ebbed. That delay is neither unusual nor encouraging. Many victims or insiders decide, for reasons of fear, confusion, or trauma, to stay silent for years. Sometimes a neighbor, a relative, or a friend hears something and only later appreciates its significance. What complicates this story is the intersection between agency action and community perception. If CPS had active concerns about more than neglect, concerns they may have relayed only to a limited set of people, the public would only hear fragments. That leaves gaps large enough for rumor to rush in. And when rumor fills the void, it reshapes public understanding. People begin to read the family story differently, not as an isolated disappearance, but as possibly the apex of a pattern of abuse, neglect, and institutional friction. In that reading, the disappearance is not merely tragic, it is symptomatic. We must talk about specific voices who have added volume to this rumor. In small towns, certain community members gain reputations for being close to events, for speaking candidly, for providing context others do not have. When someone with that claimed proximity asserts that children in the home were allegedly sedated or repeatedly abused, the allegation takes on a different weight. But it remains an allegation until corroborated. The ethical line for journalists, for documentarians, and for people producing content about crimes is to label such claims as allegations, to seek validation, and to avoid amplifying false or unverifiable claims that could irreversibly harm people's reputations. It is possible, of course, that these neighborhood claims contain kernels of truth. It is also possible they are shaped by grief, anger, or the human tendency to make sense of a senseless loss by finding patterns. The only safe path forward is careful corroboration. You look for medical records, you look for CPS files, you interview multiple independent witnesses, and you test physical evidence. So what would investigators do with this allegation if they took it seriously? First, they would attempt to identify the original source and get a formal statement. Who heard the alleged confession? When did they hear it? Was it a private lament, or did the person say words that indicated knowledge of a crime? Next, investigators would search for contemporaneous corroboration, records of CPS visits, case notes, removal orders, medical reports indicating prior injury or sedation, and phone records showing calls to particular people at particular times. If any of these elements existed, they could be connected in a mosaic that either bolsters or collapses the allegation. Finally, if evidence supported probable cause, subpoenas, warrants, and arrests could follow, sometimes years after the original allegations, because, as we noted, criminal statutes often let prosecutors act even after long delays. That, in turn, is why a private admission, however informal, can become an accelerant for a long-term legal process. Now let us turn to a crucial sociological dimension, the power of silence and the cost of speaking. In families and small communities, silence has many faces. For some, silence is protection, shielding a child, shielding a neighbor, or shielding a fragile economic or social network. For others, silence is fear. Fear of retaliation, fear of disbelief, or fear that speaking will shatter what remains of a life. For victims, silence may be survival. For bystanders, silence can be complicity. And when a case like this, a missing child with a thick fog of rumor, drifts through a town, the weight of silence can crush the will of witnesses to come forward. That is why any script or documentary that touches this subject must treat witness protection, trauma-informed interviewing, and ethical reporting as essential. To demand testimony without offering safeguards is cruel. To accept silence without pressing for safety and support is ineffective. For anyone watching from the outside, the relevant action is to understand how the system works and to encourage people who may have testimony to reach authorities or hotlines in ways that protect them. Let us imagine for a moment a possible investigative path that begins with the alleged confession. Investigators identify the neighbor who heard the remark. They take a recorded statement. They subpoena CPS records and discover incident notes that corroborate at least parts of the story, multiple documented visits, alarms raised by medical professionals, or observations of injuries inconsistent with the family's account. They then locate a medical record indicating a child had sedative levels in their system at some point. Now you have a chain: neighbor account, agency documentation, medical corroboration. At that point, an arrest would be more than rumor. It would be supported by a paper trail. That is the ideal path from allegation to credible action. It is also rare in its completeness. More often, investigators find pieces and must decide whether to press for more or close a file for lack of evidence. That decision, to proceed or to pause, shapes lives permanently. We must also discuss motive and opportunity without presuming guilt. If the alleged confession was made, why would someone say it? People confess privately for many reasons: a desire to unburden, a strategic move to another party, or even a calculated attempt to create a narrative. Understanding motive is as important for investigators as establishing timeline and physical evidence. Opportunity matters too. Did the incident alleged to have occurred take place when family members were alone? Were there people who had unfettered access to the children? Did the physical layout of the home make certain events possible? Questions of opportunity are often prosaic. Who was home when? Whose vehicles appeared in surveillance? What did phone records reveal about movements? None of these questions require moral judgment. They simply require patient, forensic reconstruction. Another essential area we must cover is the relationship between CPS actions and law enforcement decisions. The two systems often intertwine, but they operate under different standards. CPS acts primarily to protect children and to manage civil custody issues. Their work is driven by the best interest standard and is not necessarily aimed at criminal prosecution. Law enforcement, by contrast, seeks evidence sufficient for criminal charges and must abide by constitutional safeguards. When CPS uncovers indications of abuse, ideally they notify law enforcement, but that does not always happen neatly. Paperwork can be incomplete, thresholds for criminal referral can be judged differently, and local resource constraints can slow action. The consequence is that families sometimes feel that CPS intervened in a way that was either insufficient or heavy-handed, and that law enforcement did not follow up aggressively. The allegation we are discussing claims that CPS had identified serious crimes. If that were true and law enforcement did not, for whatever reason, act decisively at the time, it would create a deeply painful dissonance for the community and the victims' advocates. That is one reason why the line between administrative investigations and criminal cases matters so much in this narrative. Now we approach the personal dimension, the human damage behind every allegation. Whether the facts ultimately show a pattern of organized harm or a series of tragic missteps, the emotional cost is enormous. For the family, whatever their culpability or innocence, public suspicion can be brutal. For neighbors, suspicion breeds fear. For children who may later come forward as victims, the trauma is lifelong. And for the missing child at the center of all of this, the deepest loss remains: her life, her laughter, the future she was denied. It is vital to remember that every speculative scenario we discuss contains actual human beings: the missing child, siblings, parents, investigators, and members of a small town who woke one day to a tragedy and have not been able to sleep since. It would be callous to reduce their pain to mere plot twists in a documentary. If this allegation catalyzes an investigation, the ethical obligation is to center victims, prioritize care, and let justice, not rumor, lead the next steps. What about the role of social media and forums in circulating these allegations? Digital platforms amplify both fact and fiction at a speed previously unimaginable. A private remark heard in a kitchen can, within days, be dissected in online threads, turned into a suspect theory in a podcast, and retweeted across continents. That amplification can be double-edged. It can pressure agencies to act, but it can also harden false narratives and create mob dynamics that make fair investigation harder. In cases like this, the best public posture is cautious curiosity. Ask questions, seek reputable sources, and support official avenues for reporting and evidence submission. Encourage witnesses to go to investigators, not to armchair forums. Demand accountability from agencies to publish verified findings, while understanding that investigative integrity sometimes requires secrecy and patience. We must also consider the practical logistics of moving from allegation to prosecution. Suppose investigators gather corroborating evidence and prosecutors decide to pursue charges. What happens then? There will be subpoenas, depositions, possibly grand jury proceedings, and if charges are filed, arraignments and trials. The timeline could stretch months or years. Defense attorneys will challenge forensic methods and question witness credibility. Prosecutors will assemble evidence from medical experts, social workers, digital footprints, and, crucially, testimony from victims or insiders. The adjudicative process is adversarial and slow, by design. So while the public yearns for swift justice, the system requires rigor. For those watching, patience will be as necessary as pressure. Push for transparency, but respect due process. Finally, ask a hard question. What does justice even look like in a case like this? Is it a prison sentence for the guilty? Is it a public reckoning that forces institutions to reform? Is it restoration and protection for survivors? The truth is that justice rarely fits neatly into one box. It must be multifaceted: criminal accountability where the law supports it, systemic reform where institutions failed, and comprehensive support for survivors, including counseling and long-term resources. If this allegation is true and leads to legal action, justice will require both the blunt instrument of the criminal law and the softer tools of community healing. If the allegation proves false, justice will require protection for those wrongly accused and for the families who suffered under the shadow of rumor. Either way, the stakes are moral as well as legal. As we draw toward a close, here is the most important takeaway: rumor is a red flag, not an endpoint. Private admissions, neighborhood allegations, and the echo of CPS files can all be the genesis of genuine investigations, or they can be the debris of grief and speculation. The only responsible path forward is methodical verification. If you are someone who knows something, a memory, a document, a tape, anything, the best thing you can do is get it to investigators through official channels. If you are a viewer moved by what you hear, encourage others to report credible information to the appropriate law enforcement office. Be mindful of the difference between sharing a claim and endorsing it as fact. And above all, remember the central human truth that runs beneath every rumor. A child was lost, and her family and community deserve clarity, care, and justice. We will continue to follow any verified developments in this matter and update you with sourced information as it becomes available. If you value careful, responsible coverage like this, reporting that distinguishes allegation from proof and centers victims above spectacle, subscribe to the channel and ring that bell so you don't miss our next update. In the comments below, keep the conversation focused on verified leads and support for survivors. And if you believe you have information relevant to investigators, please reach out to the official hotline or local authorities rather than posting uncorroborated claims here. Thank you for listening closely and thoughtfully. This case is heavy, and the truth will require time, patience, and courage from witnesses and investigators alike. Until next time, keep seeking evidence, not rumor, and insist on justice founded in facts.